Okay, Mansi, we can start now.
A pleasant evening to everyone. I am Ashok Chaitanya on behalf of Team Law Statistics and the organizing committee, namely Ms. Nikita Bansal, founder and CEO, and Ms. Shobna Agarwal, co-founder and managing director, welcome you all for this webinar and present a heartfelt gratitude to our honorable speaker, Advocate Ashok Chaitanya sir. The topic for today's webinar is the law of F.I.R. and police investigation. Now, I will quote some lines about Advocate Ashok Chaitanya. He is presently working as...
Wait a second. Mansi, please wait a second. Sir, please switch on your camera. Sir, Ashok sir, please switch on your camera. Okay. Mansi, you may continue now.
Good evening, sir.
Good evening, everybody.
Ashok sir is advocate at Supreme Court of India. He had worked with Indian Air Force for 15 years and also he is Central Government Senior Panel Counsel at Armed Forces Tribunal. Sir, we are pleased to have you here and without taking much time, I would like to hand over the session to sir. Sir, please continue.
Thank you, Mansi. Thank you, my executive and its founder, Ms. Nikita Bansal. He is also the CEO of this platform and the organization. Thank you very much, Ms. Shobna Agarwal, who is the co-founder and the managing director of this very beautiful organization. Law Statistics, as we all know, is a platform run by youngsters who are striving so well for legally educating the masses. This platform provides a very, very effective platform to the students, to the lawyers, to the researchers, through their webinars, workshops, and this is really something which the law profession has done must acknowledge and appreciate. Thank you very much for providing me this platform to share whatever the little knowledge I have with me, with you all. I'll straightway come to the topic. The today's topic is the F.I.R. and the police investigation.
Sir, sorry to disturb you. Just please adjust your mic. Your face is not visible. Oh, sorry. Please adjust your camera. Sorry.
Yes.
Yeah, sir, it's fine now.
Thank you.
Thank
So,
you.
the two words we get from the topic that is given to us, that is the F.I.R. and the investigation. I hope I am audible to everybody. Somebody is waving hand. Am I audible to everybody?
Yes, you are audible.
So, let's see whether the word F.I.R. has been defined in the code. When we talk about the code, I refer to the criminal procedure code, and then we will come to the investigation. Here we would be restricting ourselves to the investigation done by the police. We all know that investigation can be done by the police and even by the general public if so authorized by the magistrate. But will be restricting ourselves only to the investigation done by the police. The word F.I.R., that is the first information report, has not been either mentioned or defined in the CRPC. The actual terminology we get under Section 154 of the CRPC is the information given to the SHO. Now we have to see 154 and 155 both. Although we would be concerning only with the Section 154, we would be skipping the 155, but just for the sake of reference, will be mentioning 155 also. Before I proceed, let's see what is the investigation. If you see, the investigation has been defined under Section 2H of the Code, and in general parlance, it means all the process or the activities done for the collection of the evidence. Exceptions apart, investigation is the exclusive domain of the police. The court cannot interfere into the investigation. And when it comes to the inquiry, we all know that inquiry has been defined under Section 2G of the Code. So the inquiry is under the domain of the magistrate or the court. I'll come little later about the Sakira Basu case also, because it may be popping up in your mind that the Sakira Basu case, somebody is sharing the screen. May I request to please...
Bhavani sir, Bhavani Singh Rathore sir, please stop presenting your screen. Bhavani Singh Rathore sir, please stop presenting your screen. Stop presenting, yes.
So I will come little later at this particular point, whether the magistrate has the power to monitor or supervise the investigation. But for the time
Guys, please stop presenting your screen. It's very problematic for the speaker to concentrate. It's a request, please don't do this.
So I'll come back to the first part of our topic, the F.I.R. Any information given to any SHO, I am the word, kindly mark the word, I am using any SHO. I am not using the word the SHO or any specific SHO. When I say information given to any SHO, here the jurisdiction is not involved. Means you don't have to see whether the SHO to whom you are giving the information has the territorial jurisdiction. And I'll explain it well a little later. Let's see what is the information that can be given to the SHO under Section 154. And before that, I just skipped. Let me explain as to how the criminal justice comes into motion and where the investigation ends. And when I say that when the investigation ends, we have also to see when the investigation starts. And for this, you have to see the chapter 12 of the Criminal Procedure Code. And the heading of this particular chapter is Information to the Police and their power to investigate. Exactly the topic that we have taken up today. The F.I.R. and the police investigation. So the entire topic is comprehended in this particular chapter 12 of the course. So when the investigation starts, investigation follows the registration of the F.I.R. Exceptions apart. I know the moment I say that the investigation follows the registration of the F.I.R., you may say, sir, kindly see the provision of section 157. I know that there are certain cases where the investigation can be launched even without registration of the F.I.R. Will be discussing it little later. But in general parlance, the investigation would come into motion only once the F.I.R. is registered. I say that the F.I.R. has not been defined or it has not been specifically mentioned with this particular name in the CRPC. And F.I.R. we say the first information report. The information which is first in time given to the SHO under section 154 subsection 1. And such information must relate to the occurrence of the cognizable offence. It means the information that you are giving to the SHO must be disclosing the commission of the cognizable offence. So if you are giving the information which discloses the commission of a non-cognizable offence, in that eventuality the F.I.R. cannot be registered. And for this, if you are giving the information relating to the commission of non-cognizable offence, it can be recorded in the register meant for it by the SHO under section 155. But in that eventuality, the SHO would not have, or for that purpose any other police officer, to conduct the investigation until the magistrate passes an order against or direction to do so. Now, I hope that you can make out the distinction between the two. The information relating to the commission of non-cognizable offence and one which relates to the commission of cognizable offence. Again, I will come back to the 154. I make 2 points. One, that such information can be given to the SHO of any police station which you don't have to see the jurisdiction. It must relate to the occurrence of the cognizable offence. Now the third thing comes that if the two requirements are complied with, the first two that I just referred, then such SHO is under legal obligation to record this information in the register meant for it, and earlier it used to be the F.I.R. register. Nowadays, in most of the police stations, you find the computer where the such information are installed into and stored in the electronic form. Now, what kind of the register would be, or whether it would be the computer, it has to be decided by the state government. It has been so mentioned in 154. Now, the question question comes, as we generally see, that whenever you approach to the SHO requesting him to register the FIR, giving the information, disclosing the commission of applicable offence, most of the time FIRs are not registered. Sometimes the police say that listing of the dusty inquiry, preliminary inquiry, and let me go into the veracity of the complaint, and if I find some genuineness, then I will register the FIR. And the SHO legally do that. The answer is given by the Supreme Court in Lalita Kumari versus State of UP. The Supreme Court says that once the information is given to the police disclosing the commission of a cognizable offence, the SHO would have no option but to register the FIR. Obviously, certain exceptions have been carved out in that case also, like matrimonial cases, the cases relating to property, the cases relating to the cyber offences. There the police has been given the leeway to have the preliminary inquiry. In the rest of the cases, the SHO has no option but to register the FIR. Now, having explained this concept, let us see that once the FIR is registered by such SHO, whether he would have the right or legal power to initiate the investigation. Now, I said that the territorial jurisdiction is irrelevant so far as the provision for registration of FIR is concerned. Supposing you have approached to an SHO who is not having the territorial jurisdiction, means under whose area the reported offence has not occurred, how he can conduct the investigation. For this, we have to see the two sections. Firstly, section 156, subsection 1 of the code, and then we'll come to the section 157. If you see subsection 1 of section 156, it gives the power to the SHO to conduct the investigation relating to the applicable cases or offences. Now here, you will find the mentioning of jurisdiction also. Let us see the wording of the subsection 1 of section 156 for a moment. It says, and I am reading for you all, subsection 1, section 156. Any officer in charge of a police station may, without the order of the magistrate, investigate any cognizable case which, of course, having jurisdiction over the local area within the limits of such station would have power to inquire into or try concerning provision of criminal authority. Now, the power of such SHO has been connected with the magistrate having jurisdiction over the offence or case in question. And this is how the territorial jurisdiction of the SHO comes into play. Now just gauge the distinction of the territorial jurisdiction when it comes to the registration of the FIR, and the one where the question comes the power vested in the SHO to launch the investigation. And that is where comes the concept of zero FIR. And I'll just make a mention of this particular zero FIR. Generally we see that the zero FIRs are registered in cases of the sexual harassment or the rape cases. But it is not so. It can be in other cases also. The moment such information is given to the SHO, who is not having territorial jurisdiction to launch the investigation, he is to register the FIR. Once the FIR is registered, a serial number a numerical number is allocated to the such FIR, and it has to be in chronological order. Like if 5 FIRs have been registered till date, and today if you provide the information to the SHO, and on the basis of your information the FIR is registered, it would be allocated the FIR number 6 followed by the particular year. So therefore it would be 6 of 2020. But if the information is given to the SHO who is not having the territorial jurisdiction, he would allocate the serial number of the FIR with the number 0 of 2020, police station so and so, and after registering the FIR, it would be referred or forwarded to the SHO having the jurisdiction, and once it reaches to the jurisdictional SHO, the FIR number as per the chronological order of that particular police station would be allocated to that FIR. I hope this concept is clear. Now, 156(1) provides the power to the police and in more specific terms to the SHO to conduct the investigation. I would try to give a reference to Section 36 of the Code also. Section 36 of the CRPC gives power to the superior officers of the SHO, which power, all the powers which are vested into the SHO is also vested into the superior officers of the concerned SHO. So therefore, if the SHO has the power to conduct the investigation, all his superior officers would automatically have the same power to conduct the investigation or to receive the information disclosing the commission of a profitable offence. Now I'll come to the Section 157. This is very, very important section so far as the investigation is concerned. And here let me make a reference or a point whether with the registration of the FIR, the investigation comes into motion. The answer could be in negative. We cannot say that once the FIR is registered, investigation would automatically come into motion. No. The investigation starts from the action taken by the SHO concerned under Section 157. In my opening remark, I said, obviously I made it clear also, but in my opening remark, I said that the investigation follows the registration of the FIR. But if you see the provisions of Section 157, and I read for you the few lines of section 157, subsection 1, which would clear the point. If from information received, this is one limb of this particular provision. If from information received or otherwise, an officer in charge of the police station has reason to suspect the commission of an offence which is empowered under section 156 to investigate, he shall then so on and so forth, will come a little later to the other part of this particular provision. Now, there has been given two modes through which the SHO receives the information for taking action under section 157. And which SHO can take the action under
Shambhas,
section
please
157?
stop presenting your screen.
Which SHO can take the action? Only the SHO who has the power to investigate under section 156, subsection 1. And as I read section 156, subsection 1, I explained it also. It means only the SHO who is having the territorial jurisdiction can take action under section 157, subsection 1. And he can take action firstly on the basis of information received. Which information? The information which is improving through the F.I.R. The first limb. The second limb, otherwise, it means it is not necessary always that the investigation can be launched only if the F.I.R. is registered. This may be an important question for those who are appearing in the judicial services examination. You may get the question. So, even the SHO receiving information otherwise than on the basis of the F.I.R., he can take action under section 157. And how he takes the action? The moment he receives such information, he forwards the report to the magistrate. And this report, in our technical term, we call it as the occurrence report. He has to send the report to the magistrate, and he is to clarify that on the basis of such report, he feels the reason to suspect or the reason to believe that such alleged offence has taken place. With the genuineness, the bona fide, prima facie bona fide of the alleged offence. It means the SHO has the right to decide whether the investigation is to be launched after the registration of the F.I.R. or after receiving any such information or to deny. This power has been given under this particular section. If the alleged offence is of serious nature and the name of the accused has not been mentioned, in these cases, it is incumbent upon the SHO to straightway proceed to the place of occurrence of the offence, which we call it as the crime scene, and to start the investigation, or alternatively to depute his subordinate to that particular place and to forthwith start the investigation. But if the offence is not that of the serious nature and the name of the accused is mentioned, he may postpone proceeding to the scene of occurrence because the name of the accused is given and the alleged offence is not so serious. This is the second option available to him. It means the investigation can be done at later stage also. Now the third option comes to that is available to the such SHO is that he may deny to the conducting the investigation. He may feel that the alleged offence appears to be unreasonable or so improbable that in all probability it might not have happened. So in that case he may try conducting the investigation. But in that eventuality he is to inform to the complainant, giving the reason. It cannot be the blanket order that I would not be holding the investigation. He is to giving the reason, explaining as to how and why he has had such kind of belief that in all probability this offence, the alleged offence, might not have happened. One thing, while explaining the F.I.R, I just forgot to mention that for giving the information, either you have to approach to the particular police station or you may give even through the WhatsApp or through the telephone. And if it is not cryptic, when you are giving the information either through the telephone or WhatsApp or through the SMS, if it is not cryptic and contains the details of the offence and the person who is giving the information, the informant's detail, it can be treated as the first information report and the F.I.R can be registered. In both the cases, when you are approaching to the concerned police station, you are going there, or if you are sending the WhatsApp or SMS or voice call, it reaches to the police station. It means in all these conditions, the information comes to the police station, but there is one very, very serious exception to it. When the alleged offence relates to the sexual assault or the case of rape, then in such cases, and where the complainant is the child or mentally ill or physically incapacitated, in that eventuality, the police has to come to the residence of the victim or to a place which is convenient to the victim. In such cases, the victim doesn't have to go to the police station. The one part. The 2-3 more ingredients and the necessary parts of the F.I.R. I just erroneously skipped, which I would be mentioning now. Once the information is given, in some state we call it as the first information statement. Because when you are giving the information, you are making a statement to the police. So we call it as the FIS, First Information Statement. And once this statement is recorded, that becomes the report, that is the FIR, First Information Report.
Sir, is this mentioned anywhere?
Come again, please.
Sir, this FIS, is it mentioned anywhere?
It is not mentioned in the CRPC, but in some of the police manuals, it is mentioned. And you will find the FIS mostly in the South Indian states. There the FIS is separate and FIR is separate. So, and like in our case, sometimes we call it as the statement. Sometimes we because I have the very limited time, otherwise I would have explained the RUCA also. In some cases we call it RUCA. It is a little different, but on the basis of RUCA, the FIR is registered. So it is not mentioned in the CRPC, but in some police manuals and in practice, they have adopted it. Now, whether the what can be other mode of giving this information? You may make an oral statement to the police. When it is made through the oral statement, such SHO is duty bound to reduce into the writing, and after reducing such statement into writing, it has to be read over to the informant, and the informant has to say that yes, it is correct. And thereafter, the FIR would be registered and a copy thereof would be provided to the informant free of cost. Obviously, then it is regarded either the signature or the thumb impression of the informant as to be a big on such FIR. This is very, very important. Now, I'll get to the other aspect, where I said that if the information relates to the commission of sexual offences or the rape offences, and you can see the sections which are mentioned, it starts from 354, 354A, B, C, and D, and we know that it belongs to the different sexual assault, and 509. These sections are called the sexual assault, and all other different kinds of offences under section 376, A, B, C, and other subsections also, these are called the offences of rape. So there is a difference between the sexual assault and the offence of rape. So in all these cases, where such cases have been committed, or where the offence of attempt of such rape, such offences. So the two things, where such offences are committed, one. Second, where the attempt has been made, attempt to commit such offences. In all these cases, firstly, the information would be recorded by the women officer. Nowadays, the women desk has been separately provided in all the police stations. And if the women police officer is not available, it has to be recorded by the women officer. It means some officer who is not belonging to the police force. The women police officer is not available in a particular police station. Some other women police or some other women officer is to be called in, and she would be recording the statement. Now, I said that where the victim is physically incapacitated or mentally ill, then in such cases the police has to go to the residence of the victim or to any other place which is convenient to the victim, and or special educator or interpreter would be employed, because the victim is cannot speak, so she would be making a statement through the indication. Now those indications can be raised only by the the educator, the special educator or the interpreter. Now when this is done, this has also to be video recorded. It cannot be that the interpreter has recorded certain things, because then in such cases if the accused is mighty person or which is in a position of influencing the system, then get the statement which is traveling to him. So that is how there is a provision that it has to be video recorded, and such educator and interpreter has to be examined in the court also. Now, so far as this brief detailing of the F.I.R. is concerned, I have explained. Now I'll jump to the investigation where I had left. I'll request Nikita to prompt me when my time is over, or when at least 10 minutes is left out, so that we are not exceeding the allocated time.
Yes, sir. I just spoke to you.
I said that under section 157, the SHO has to send the occurrence report to the magistrate, and I explained the three options available to him. In serious crime, he is to straightway rush to the crime scene and to start the investigation, or to depute his subordinate officer to conduct the investigation. Second, where the crime is not of that serious nature, and where the details of the accused persons are given, in that eventuality, he may defer conducting the investigation forthwith. Third option is that he may deny conducting the investigation. Now, such occurrence report is to be sent through the superior officer. So, the SHO cannot directly send it to the magistrate. When it comes to the superior officer is to apply his mind on the report sent by the magistrate,
वेबिनार चल रहा है, ठीक है? तो अभी
he
लैपटॉप
would
नहीं है,
either
तो मैं
accept the report
7 तक भेज दूँ, क्योंकि अभी ये चलेगा वेबिनार, आधा घंटा चलेगा.
start the investigation,
हाँ.
or he himself may start the investigation. Because
अगर उसको बोलो
under
कि
he has
फुटनोट्स
all the
डाल
powers
दे,
of the
एंड नोट्स डाल दे.
Now,
हाँ, एंड नोट्स डाल दे.
if he accepts the SHO's report, because in order to eventually the investigation is start, there is no problem.
हाँ,
But
रेफरेंसेस डाल दो,
first
बाकी है
eventuality where he accepts the report of the SHO, wherein the SHO has refused to conduct the investigation.
इसके में स्पेसिंग का प्रॉब्लम नहीं है, इसको सिर्फ वर्ड्स प्रॉपर करने बोलो कि 2100 वर्ड्स जो है वो कर दे. ठीक है ना? बाकी तुम्हारे वाले में मैं बता दूंगी, और मैं अभी तुमको ना 8 बजे के करीब कॉल करूंगी. ठीक है ना? तब तक उसको बोल देना कि सब हो जाएगा.
But it would have this significance if the investigation has been refused. In that case, and this report comes to the magistrate under section 159. Section 159. For a moment, I would hold here, and again I take you to the, section 154, subsection 3, then with section 156, subsection 3. I explained the F.I.R., but purposely I left one aspect of it, where despite the fact that you have given the information to the SHO, disclosing the commission of a cognizable offence and the SHO refuses to register the F.I.R. He doesn't register the F.I.R. which normally happens in most of the cases. Then what is the remedy available to you? The remedy is under section 154, subsection 3. Mind it, I am not talking about section 156. I am talking about section 154, subsection 3. Under this provision, you have to send the contents of the information to the superintendent of the police through the registered post. Why through the registered post? So that there is an acknowledgement, there is a valid receipt showing that you have actually sent the information to the SHO, or you can personally send it, submit it to the superintendent of the police. Nowadays there is a desk provided in the SP office where you get the acknowledgement. The seal is affixed and acknowledgement is given. So once this consent is given to the SP, superintendent of police, he is to apply his mind and if he finds that yes, the information consists the delegation or which discloses the commission of the cognizable offence, he is to either start the investigation, and obviously for starting the investigation he would register the F.I.R. or he may directly SHO to register the F.I.R. and start the investigation. The third option would be that he too would not be taking any action on that particular the information that you have provided to the SP. So, if you are aggrieved by the action of the SP also, then you can approach to the jurisdictional magistrate under section 156, subsection 3, and you can request him to direct the police to conduct the investigation. Because of the limit of paucity of time, I am not going deep into it. Otherwise, it's a very, very lengthy topic. Suffice it to say that,
Sorry to interrupt. Sir, sorry to interrupt. Could you please end up the session in the next 5 minutes?
Okay, then I'll rush out. So,
because there are many queries in the chat box. We have no questions.
Yes. I'll finish it within 5 minutes. Now, we have seen that the magistrate can pass an order under section 156, subsection 3 to conduct the investigation. And now I will come to the 159 where I left, and where the occurrence report comes to him. There also he has the right or the power to pass an order directing the police to conduct the investigation, or he himself may start the inquiry, because the magistrate cannot conduct the investigation. Now I said that what is the investigation? I said that the investigation is the process of collection of evidence, and therefore it would include the arrest, the search and seizure, collection of different kind of evidences, the forensic evidences, the scientific evidences, the recording of the statement, and the investigating officer has the power to record the statement of all those persons who appear to have acquaintance with the alleged offence, and he may issue the notice under section 160 of the CRPC, and after receipt of the 160, such person has to appear before the IO, and his statement would be recorded, and such statement would not be signed by the maker of the statement. Now, the section 57 of the CRPC says that the investigation has to be completed within 24 hours if the person has been arrested. And after 24 hours, if the investigation is not completed within 24 hours, the discretion lies with the magistrate under section 167. Because within 24 hours, you have to present the detained person before the concerned magistrate. And he is to apply judicial mind. He may demand to the judicial custody, he may demand to the police custody, or he may even discharge the person. Now, the police custody can be granted in initial stage maximum for 50 days. It may be in segments, like for 3 days at a time, then again for 4 days, but in totality it cannot exceed 50 days. Now, quickly I'll jump to the rest of the things. After the collection of the investigation, the investigating officer or the SHO has to analyze the evidences collected. And if he comes to a conclusion that the person against whom the allegation has been made appears to not have committed the offence, so he is to record such opinion under section 169. And as I said, that the investigation has to be completed initially within 24 hours. And, and it practically doesn't happen. But suppose if the investigation is completed within 24 hours and the person has been arrested, and the investigating officer comes to a conclusion that such accused person appears not to have committed this offence, then such arrestee would be released, but the bond, and if required, the surety bond would be obtained by the SHO, and he would be bound to appear before the magistrate if required. And if he comes to a conclusion that yes, such person has committed the offence, or if the alleged person has not committed, some other person has committed this offence, so such opinion has to be recorded under section 170, and a report has to be filed before the magistrate under section 173. Now, during the investigation, different things, different proceedings would be conducted, different activities would be done by the investigating officer, and all such activities would be recorded day to day in the diary which is called the police diary. So this has to be recorded in that one, but the accused doesn't have the right to have the access to the police diary, acceptance part, and because we have the paucity of time, I'm not going into the evidence etc. So that is why I'm using the word acceptance part. Generally, the police diary would not be, accessed by the accused. I think I am transgressing the allocated time, so I would end up here. If there is any question, so I would.
So there are few questions in chat box.
Yes, sir. Like the first question is asked by Pranav Vomik and Suresh Goyal. Probably have the same question. This officer can discard the F.I.R. or not?
Can you come again? There was some problem with your. Yes. Please come again.
Whether police officer can discard the F.I.R. or not?
No, the police, once the F.I.R. is registered, there will be two stages. One, as I said, that F.I.R. will be registered under section 154, subsection 1. But whether the investigation would be launched or not, this decision would be taken under section 167. 1. So, if the investigation is launched, the evidence would be collected. Now, under the investigation, there would be several circumstances. Like, one, the evidence might be showing that so-and-so person has committed the offence. Actually, the offence has happened, and so-and-so person has committed the offence. The second eventuality may be, it is revealed that yes, offence has happened, but somehow the culprit could not be traced. Like 50 cases. like the snatcher coming to the bike, snatches the chain and runs away. Now it is established that yes, this occurrence has happened, the offence has been committed, but despite all efforts, the snatcher could not be traced because there was no number plate on the bike, or in a traumatic condition, the victim could not note down the bike number, and there was no CCTV camera, etc. So this can also be there. The third condition may be that there may not be the sufficient evidences so that the police may say that, like in Ashok Talwar murder case, they say that we are not having the sufficient material to show that who has actually committed the offence, and therefore we are filing the final report. Now in CRPC duty, there is a mention of only the police report, but we say that there is a charge sheet, there is a final report, there is a closure report, there is a conciliation report. If you go into the South Indian states, there is generally mentioned the A report, the B report, and the C report. So once the F.I.R. is registered, some report has to be filed, and it can be concerned only by the court of law, either through the or by the High Court exercising the jurisdiction under Section 482 here.
The next question is similar, like if the police officer does not register the F.I.R. and threatens the complainant, what can be done?
I have explained this in detail. Then you have to take the reports to Section 154 of Section 3, send the contents of your information to the SP. Even if the SP doesn't take any action, approach to the jurisdictional magistrate under Section 156(3). File the complaint over there. The magistrate may pass the necessary direction.
Okay. Sir, next question is asked by Chaitanya. Not in principle, but if it doesn't disclose any cognizable offence, then the police officer can suggest you to file a private complaint to the magistrate under 200 CRPC. Lalita Kumari makes it obligatory to record an F.I.R. if it discloses an cognizable offence. Discarding depends whether the information discloses. Further, he can file a closure report, etc. if cognizance is not required.
No, I have understood. Dr. Chaya, I know him. He has not put the question. He has given the explanation, and I have already explained it. If the information discloses the commission of non-cognizable offence, the police sergeant has the right to or power to conduct the investigation. All it can do that it can regard the information under Section 165, we call it as the NCR, and refer the informant to the magistrate. And obviously we have to file the private complaint. And in most of the, if you go to the Uttar Pradesh, you find that NCRs are sent to the magistrate, and magistrate may pass the necessary direction. So he has explained the legal position. He has not put the question. Next question.
Sir, there are no other questions in the chat box. If anyone has any query, he may ask sir, or you can drop your queries in the chat box instead. Does anyone have any query? Okay, there is a question. What after registering NCR?
After the registration of the NCR, I said that even the copy of the NCR has to be sent to the magistrate, and by registering the FIR, the SHO refers concern or invited him to approach the jurisdictional magistrate. So the NCR can be taken as a private complaint, and the cognizance of the offence can be taken by the magistrate under Section 190. That is not today's topic. It's a very lengthy topic. And after taking the cognizance, he may direct the complainant to get regarded his statement under Section 200 and the subsequent provisions would follow. So the private complaint procedure would come into place. But the state may directly police to conduct the investigation, and in that eventuality, the police would conduct the investigation and would have all the powers except the power of arresting the accused person, because again, even during that investigation, for making the arrest, he has to obtain the warrant of arrest from the police.
Okay, sir, there is a question by Anmol saying powers of police officer under CRPC.
It's a very, very lengthy topic, and perhaps I'm afraid that I would not be able to explain it within such limitations.
Sir, can you please provide a gist of it? Just to satisfy the question.
Just 1 second. In some I would say, to prevent the crime, to investigate the crime if at all it has happened, and to collect the evidences and produce it before the court of law, so that the culprit can be brought to book and he can be punished.
Okay, after filing of FIR, the complainant has to be given a copy of an FIR. So what can we do if the police refuses to give the copy of FIR?
Very, very important and very pertinent question. Nowadays, because if we are not having the copy of the FIR, and especially for the accused person, how can you seek the bail? For that, we always need the copy of the FIR. And we also know that what does the police do? Now, as per the direction of the Supreme Court, all the FIRs are to be uploaded on the official website of the concerned police. And you can check through from there. Exceptions are only the offences of the sexual offences and the rape cases, and those offences which are touching the security of the national security. Those offences, the FIR relating to those offences cannot be uploaded. So from there you can have, and if the copy of the FIR is not provided, obviously it would not go into the root of the case, but it is kind of irregularity and lapse on the part of the police and the Department Election Committee.
Okay, sir. In case of sexual harassment, the section states that when a man commits, what if a woman commits sexual harassment on a woman or men, will the FIR be lodged in the same way?
See, for that you have to go into the substantive law. The RPC is the procedural law. So first you have to see whether offence has been committed. So far as offence of rape, etc., the sexual offences, ITB, it has not been provided in our substantive law, that is IPC. Exception is only in the POXO cases where the gender discrimination is not done. So it led to the child falling under the provisions of the POXO, it's fine. Otherwise, in IPC, is not an offence, and therefore there is no.
The Walker wants to learn directs. I am a beginner in law.
For learning the direct, all our seniors always say that the best thing for a law professional is to go through the Fair Act and the Fair Act and the Fair Act once, twice, time and again. And every time you find something new when you read a particular provision under the Fair Act. And to learn it, I think reading it time and again, and obviously the practice makes the man perfect. So the more you do the practice, the more you learn. So that is how it can be.
So what are the provisions under which FIR can be lodged against women for sexual harassment? This again is a subject.
I mentioned because again you have to take reports to the IPC. It starts from 354. 354A, B, C, D, then there are 509. Even if you see that, if I'm not missing it, 294 or 292. I'm not sure very very trivial kind of sexual harassment. So you have to take recourse to the substantive law. There are other laws also nowadays. If you see the sexual harassment at work, then again that there is a separate and distinct provision made and procedure made. So for this you have to take recourse to the substantive law.
Okay, sir, that's all.
So I'll sum up my today's lecture by thanking Nikita and Shobana for providing me such a beautiful platform to get connected with you all. I am the very nice audience. I have conducted so many webinars during this lockdown, but this is amazing, overwhelming. Thanks a lot.
Thank you so much, sir. Honorable Advocate Ashok sir, team members, and Nikita Bansal, founder and CEO at Law Statistics, and all the participants present here. I, Shobna Agrawal, co-founder and managing director at Law Statistics, would like to extend a very hearty vote of thanks to our honorable speaker, Advocate Ashok sir, for such a wonderful session. We are really enlightened by your knowledge and presence, sir. Our heartfelt thanks to our participants and all the team members. We are looking forward to have many more sessions with you, sir. With these warm words and a kind message, we would move to end the today's webinar. Thank you so much, sir.
Thank you so much, sir.
Thank you so much, sir.
Thank you. Thank you.
So everyone can leave now, and before leaving, please fill the attendance form.
Yes, fill the attendance form and then leave. Okay, all the members